Hello, my name is Rocio Mendoza, and this is my presentation on equitable remedies. So I hope you do enjoy. So the contents that we're gonna dive into this presentation is first legal and equitable remedies, and what is the difference between them. Second, some examples of equitable remedies. Third, the history of equitable remedies, and fourth, two Arizona cases on equitable remedies. So, legal and equitable remedies. So, legal remedies is money compensation, and equitable remedies is like an injunction relief, which is one of the types of equitable remedies, and it doesn't deal with any money. And the difference, as I said before, um, legal remedies are about money compensation, and equitable relief is about stopping the defendant from doing something they are not supposed to do, which is injunction relief. Another thing to add on equitable relief is that the law requires a defendant to conduct or desist from performing a particular act, just like I mentioned before. Injunction, specific performance, and restitution are common sorts of equitable reliefs which will be further talked into this presentation. These equitable contents are and procedures are distinct from permitted doctrines and procedures. So that'll also be translated into the history of equitable relief. So the history of equitable relief was a division that happened in England, when distinct courts of law from those equity existed. In America, certain states established chancery courts, which only deal with equitable remedy. In other states, common law courts had the authority to utilize equity authority. Separate courts of chancery are mostly outdated today, as the same court that can create legal remedy may recommend an equitable one. Courts that may be reluctant to grant equitable relief due to with particular performance, which is one of the equitable relief types. It happens because equitable remedies frequently call for the court supervising the remedies to ensure that the defendant follows the court order. In contrast to certain areas of the law, the Supreme Court has been likely to encourage the application of equitable remedies. And the reason why courts are so hesitant to grant equitable relief, it's because, as said before, the supervising of it, just overlooking it, they just do not want to really deal with that, which is kind of strange, but at least the Supreme Court knows the importance of equitable relief. So the examples or the types of equitable relief is one of the many that I could find, but these are like the most common ones. Specific performance, which is a court order requiring the party that made the offer to perform the duties that they agreed into that was agreed in the contract. Specific performance is a substitute to damages that the court may grant to its discretion, subject to a variety of conditions. Injunctions are another equitable relief remedy, which is also accessible in contract, and it's also a tort. It is a court order ordering someone to cease doing something they should not be doing. A damaging breach is a commitment made by an individual not to do something. In this instance, not to take another person. A breach is an assurance in a contract, which ultimately, which is on the same thing as a contract. Restitution is another type of equitable relief. Restitution is a remedy that can be utilized in a wide range of situations, including cases where the contract was prevented due to the incompetence or deception of the other party. Cases where the other party violated, and cases where the party requested restitution infringed. Excuse me. Restitution, as the term suggests, is the return to one party of what they contributed to the other. And that follows two Arizona cases. that these equitable relief examples have been demonstrated. And one of the first ones, you can't really see it, but the first case is Murdoch versus Pearson, which happened in 1985. In this case, Murdoch Bryant was it's a construction company, an Arizona corporation, which seeked out a recovery for fraud, breach of contract, and restitution against the defendant, Taylor Pearson, which is another company. On the basis of equitable principle of restitution, the matter was presented to a jury. The jury returned a verdict of $392,000 for Murdoch against all of the defendants. There's other defendants rather than Pearson, but it was more directly towards Pearson. The trial judge recomputed damages, decided on numerous post-trial arguments, and entered a decision against all the defendants and awarded Murdoch compensation of $273,000 plus attorney expenses and denied any relief on defendants' objections, deeming verdict instructive only. All the defendants requested an appeal. And the rest is history. Then the second case is very recent, which is the state of Arizona versus the Navajo Nation. Despite the Navajo Nation having the right to reuse the reservation's plentiful water sources, the Navajo people confronted a water scarcity problem similar to that many in the western United States. According to the Navajo tribe, the federal government's attempts to assist the Navajo people with their water needs were insufficient to fulfill the United States Trust commitments under the 1868 treaty. The Navajo tribe filed suit to the U.S. to take serious measures to guarantee the needed water, such as analyzing the tribe's water needs, creating a strategy to acquire the required water, and maybe constructing pipelines, pumps, wells, or other water facilities. The Navajo tribe's suit was rejected by the United States Court of Appeals for the District of Arizona, but the Ninth Court overturned it, claiming in significant part of the United States has an obligation according to the 1868 treaty to undertake initiatives to guarantee water for the Navajo people. So, the Supreme Court of the District of Arizona is pretty messed up for this, but at least the Supreme Court did acknowledge the needs and the requirements of water for the Navajo tribe. And these are my sources for what I presented today, and thank you for having me.